Here's the secret as promised, and it's right there in the Georgia Code for family law cases. The Georgia Code states that in all cases where custody of a child is at issue between the parents, there is no assumption of a right to custody of the child by either the mother or the father. In addition, custody determinations cannot be made by a jury. Only the judge hearing the case can make that determination. The judge's duty is to make the determination of what is in the best interest of the child or children and what will best promote the child's welfare and happiness, and then make the custody determination based on those factors. The judge can then order sole custody, primary custody, and secondary custody, or joint custody, whatever the judge determines is best for the child. The Georgia Code says that the judge may consider any relevant factor, including, but not limited to, the following. Number one, the love, affection, bonding, and emotional ties existing between each parent and the child. Basically, this refers to the relationship between the parent and the child and what custody determination would be best given that relationship. Number two, the love, affection, bonding, and emotional ties existing between the child and his or her siblings, half-siblings, and step-siblings, and the residence of such other children. Basically, this refers to the relationship the children have with each other and what custody determination would be best given that relationship. Number three, the capacity and disposition of each parent to give the child love, affection, and guidance to continue the education and rearing of the child. Basically, this refers to the parent's ability to be a good parent and give the children the love and guidance and support that they need. Number four, each parent's knowledge and familiarity of the child and the child's needs. This pretty much refers to your knowledge of what your child needs to thrive. Are you aware of all of their needs, especially if they have special needs? In a nutshell, how well do you know your child and their particular circumstances in life? Number five, the capacity and disposition of each parent to provide the child with food, clothing, medical care, day-to-day needs, and other necessary basic care with consideration made for the potential payment of child support by the other parent. This factor refers to the parent's fitness and ability to competently care for the child. Will they thrive on your care? Will you make sure they're well-fed, safely housed, wearing appropriate clothing for their circumstances? Will you be aware of and take proper care of their medical, dental, vision, and other health needs? If the judge is going to give you any level of custody, they have to feel confident that the child will do well while in your care, however much or however little time that might be. Number six, the home environment of each parent considering the promotion of nurturance and safety of the child rather than superficial or material factors. This factor allows the judge to consider the living conditions the child will experience when they're with you. Do you have safe and secure housing? Are you couch surfing among friends with no real place to call your own? Do you have a room for the child? If there are multiple children, do they each have adequate sleeping accommodations? They don't necessarily all need to have their own bed, but if you have 4 children and only 1 bed for them, that's the kind of situation that this factor brings into consideration. Number 7, the importance and continuity in the child's life and the length of time the child has lived in a stable, satisfactory environment and the desirability of maintaining continuity. This is an important one. In a lot of circumstances, the child has lived a particular way for a long time, and this factor allows the judge to consider what kind of change to that continuity is being requested by one of the parents. Many times, children build a little community around themselves, such as school, extracurriculars, friendships with local kids and neighbors, an extended family, a regular routine, etc. They dig roots into the local soil, and the judge can consider these roots in making a custody determination. Will a change be beneficial? Perhaps if the roots aren't really healthy, or maybe it won't be beneficial. It's again determined by the circumstances. Number 8, the stability of the family unit of each of the parents and the presence or absence of each parent's support systems within the community to benefit the child. So here, the judge can consider stability factors and the support each parent has around them for raising the child. For instance, the presence of grandparents, cousins, aunts and uncles, close friends, that whole "it takes a village to raise a child" concept. Number 9, the mental and physical health of each parent. This one's pretty self-explanatory. How healthy is each parent mentally? How about physically? When it comes to the mental health component, the court is looking primarily at issues of safety of the child when in that parent's custody or care. Also, is that parent going to remember and be capable of doing the caretaking that the child needs? If they're on meds, are they compliant with their medicine regimen? If not, there could be adverse consequences for the child, and the court can consider the risk of these consequences in making the determination. As far as physical health goes, shows, the court can consider a parent's mobility and the ability to do the things physically required to raise the child, as well as the safety of the child if there are severe physical impairments that could put the child's well-being at risk, even if unintentionally. Number 10, each parent's involvement, or lack thereof, in the child's educational, social, and extracurricular activities. So this refers to how involved each parent is in the child's life. For example, do you know who their teachers are? Do you do things like attend school events? Do you ever have lunch at school with your kids? Do you attend their extracurricular events? In essence, how involved are you in your children's lives? Number 11, each parent's employment schedule and the related flexibility or limitations, if any, of a parent to care for the child. This is a very common one that comes up in custody cases I've been involved with. The judge looks at the custody request from each parent and their ability to make that custody request work, and that's part of their overall custody determination. For instance, suppose both parents want primary physical custody, but one travels during the week from, say, Monday through Thursday and the other one doesn't. That would probably make this factor weigh in the favor of the parent who's not traveling. What if one parent wants primary physical custody but works very late and the children would be in daycare until 7 p.m., while the other parent wants 50-50 joint custody and is off work by 5 p.m. every day? Well, that flexibility could weigh in their favor for this particular factor. Number 12, the home, school, and community record and history of the child, as well as any health or educational special needs of the child. This one is basically about the quality of the child's surroundings and how well the child has done in those surroundings. It's also about the impact that any particular custody determination could have on the health or special educational needs of the child. As an example, if the child has deep roots in the community they're in and has been getting special needs help at their school, and one of the parents wants to have primary physical custody in another school district 20 miles away, this factor may weigh in favor of the parent who can keep them in the school environment that they're in now. Number 13, each parent's past performance and relative abilities for future performance of parenting responsibilities. The important word here is performance. How involved has each parent been in the life of the child up to this point? What kind of parent have they been? And looking to the future, how involved are they likely to be in the child's life? And what are their relative abilities to continue to be very involved in the child's life? Number 14, the willingness and ability of each of the parents to facilitate and encourage a close and continuing parent-child relationship between the child and the other parent, consistent with the best interests of the child. So this one is really key, and it's the court's opportunity to consider who's more likely to be the more cooperative co-parent in the future. I have personally seen cases where the award of primary custody was made to the parent whom the court felt would be more willing to work cooperatively with the other parent. It also considers who is more likely to promote a close relationship between the child and the other parent. Number 15, any recommendation by a court-appointed custody evaluator or guardian ad litem. So sometimes the court will request a third party investigate and weigh in on the circumstances of the case, the parties, and the children. The court can use a custody evaluator or a guardian ad litem for this purpose and consider their recommendations. Number 16, any evidence of family violence or sexual, mental, or physical child abuse or criminal history of either parent. So the short story here is that any of this kind of evidence is not going to weigh in favor of the person against whom that evidence exists. 17, any evidence of substance abuse by either parent. Again, if there's evidence of this kind of abuse by either parent, it's most likely going to put this custody determination factor in the other parent's favor. It's important to note that the judge can use any relevant factors in their determination of initial custody, including, but not limited to, these 17 factors. What I've seen most often is that parents are pretty evenly matched on most of the factors, perhaps on 12 to 14 of them, but it's those other 3 to 5 factors where the determination is usually made. That's why it's so incredibly important to not only understand all of these factors, but also have competent legal counsel who could help you evaluate how you stand in each of the 17 factors and identify which of the factors will be most applicable in your own custody situation. Hey, thanks for watching. This stuff is so important, and on behalf of your kids, I'm so glad you took the time to view it, and I hope you got a ton of value out of it. Go ahead, please, and click subscribe or like or follow, whatever is appropriate for where you're watching this. Please share this video with other parents and leave us some comments, even if you disagree with something I said. Just keep it polite. I look forward to seeing you on the next video.